Employee retaliation. Hello, I'm Melva Tate, CEO and Human Capital Strategist for Tate and Associates. Tate and Associates is the parent company of Strategic HR Partnerships, Career Touchdown, and Melva Tate Speaks. The issue of retaliation has been one that's been on my plate for a couple of weeks now. I've had a young lady that I mentor in the HR field ask questions about employment retaliation as part of her homework for her master's degree. I've had a client ask me about employment retaliation and ensuring that they were doing the right thing concerning a case with an employee who made an internal complaint. And then I also had an HR colleague call and said, hey, I'm dealing with an issue at our work environment on retaliation. So I thought it was timely just to put together this short presentation to talk about what retaliation is, what it looks like, and things that you can do to prevent it within the workplace. And I'm using a slide deck that was provided by SHRM, the Society of Human Resource Management, to help explain these issues. So retaliation is a big issue that we're dealing with. It's probably the most frequently alleged basis of discrimination that's out there now. And we can be honest about it as part of human nature. We all know we get caught up in our feelings. People want to actually lash back out or retaliate against someone who's accused them of wrongdoing, whether they were right or whether they were wrong. And this tendency is particularly important for supervisors whose employees have accused them of employment law violations. So we see this happen more often where supervisors will lash out because someone has accused them of doing some wrongdoing. The EEOC has been dealing with this issue again. It's been on the rise, so we're seeing more and more cases. And because of that, it's essential for all supervisors, people in HR, people in management positions, know how to recognize retaliation, prevent it, and avoid situations from happening within their organization. So real quickly, we're going to talk about 5 things. I promise it's going to be quick. We'll talk about what constitutes retaliation, the importance of complying with the laws around retaliation. We'll talk about the difference between whistleblower protection and retaliation within the workplace. We'll highlight the employment laws that protection or retaliation protection is covered under, and then just ways to prevent it within your workplace. So what constitutes retaliation? Retaliation is defined as an action taken in return for an offense or an injury. In the employment context, retaliation occurs when an employer takes adverse action against a covered individual because the employee engaged in what we consider a protected activity. So it could be an adverse action, covered individual, or protected activity. We're going to explain those terms to you so you have an idea of what we're talking about. What is an adverse action? An adverse action is an employment when an employer takes action against an employee to keep them from imposing a discriminatory practice and from participating in employment discrimination proceedings. An example of that would be terminating, refusing to hire, denial of a promotion, threats, negative performance reviews, or an increased monitoring of that employee. So keep in mind, even if the alleged wrongdoing was committed by a different employer, the employee is still protected and the employer cannot take adverse action against them. What does that mean? I was working at a retail store down the street. I accused the manager of sexual harassment. I left that store while the EEOC was investigating that claim. It had not been resolved, but I needed another job. So I went down the street and started working at the other store. A competitor, someone within that store finds out that I filed a suit against my former employer, and now I'm being retaliated against for fear that I may file the same or similar case there. That's what it looks like. And then the covered employee, who's covered? So a covered individual is an employee who has opposed an unlawful practice, or they participated in the proceedings, or they requested an accommodation. And that accommodation could be related to anything in their protected or covered grouping, whether that's race, color, sex, disability, age, national origin. All of those things are covered. Individuals who have a close relationship to someone who's covered is also now covered. An example would be it's illegal to terminate an employee whose spouse filed an EEOC complaint for harassment or unfair pay. It could be a cousin, it could be a roommate. That person also becomes covered if they voice concerns or participate in those proceedings. And protective activity, what is that? So, opposition to a practice believed to be unlawful discrimination as long as it's based on reasonable, good faith belief and the manner of opposition is reasonable. An example is complaining to anyone about alleged discrimination against oneself or other employees. So, I did not get the promotion. I'm saying I did not get the promotion because I'm female, and so I tell my other female coworkers that they won't promote females because they don't want women being a boss, and so now that action becomes covered. Whether or not the claim was actually valid, I may not have been qualified, but because I complained to others, now I'm starting to be retaliated against. And I filed an EEOC suit complaining that I didn't get the promotion, and they found no cause, but I'm being retaliated against because I made that claim and I voiced it to others. Now that becomes protected activity. A protected activity may also include requesting a reasonable accommodation based on religion or disability. We can really get in a lot of trouble by not providing or even addressing the employee's request for a reasonable accommodation. To show retaliation, the employee has to prove a couple of things. They've got to show that they engaged in protective activities, such as reporting unlawful discrimination, whether an internal claim or to the EEOC. They've got to, the employer knew or believed that the employee engaged in protective activity. So whether that was actually a complaint filed internally or you heard it through the grapevine, or they suffered an adverse employment action based on engaging in protected activity. All of those which would constitute retaliation. It's important for employees to comply with anti-retaliation laws for a number of reasons. These laws encourage employees to come forward. We want employees to work in a safe environment. We want them to work in a workplace that they find enjoyable and rewarding, and we want them to feel empowered to come and express issues that go on within the workplace that management may not be aware of, without fear of losing their job or being retaliated against. Employees are becoming a little bit more savvy. They understand what employment retaliation protection looks like. They can Google it. They are on social media. So access to this information is more prevalent now than it was in the past. So they know more and they act upon it. So those are some of the reasons why we got to do a better job of complying with anti-retaliation laws. So the difference between whistleblower and retaliation, and they are distinct. Most people will try to use them interchangeably, but they are distinct protections for employees. Whistleblower claims relate to conduct that may threaten public safety. It could be something that wastes taxpayer dollars, or it could be something that violates public trust in government. Examples include dumping chemicals in the pond behind the manufacturing facility, submitting fraudulent claims for reimbursement if you've got a federal grant, or using your public office for personal gain. All those would be examples of how the whistleblower policy is used. And then retaliation relates to complaints about the employer's illegal interference in someone voicing their concern about what they consider unlawful conduct, whether it's valid or not. let the internal processes or the EEOC and external agency can help determine whether those employment actions were valid or not. But once retaliation comes into the picture because the employee simply voiced that concern, either verbally or written, then that is what we consider retaliation. So examples are an employer disciplining an employee just for alleging workplace gender discrimination, and an employer terminating an employee who reported sexual harassment, not themselves, but a coworker. So that's what retaliation looks like. The laws that protect employees under retaliation that kind of fall under that, we got the Age Discrimination and Employment Act, anyone over the age of 40. We got ADA that helps individuals with a disability. We have Title VII, or the Civil Rights Act of 1964, the Equal Pay Act, FLSA, and then FMLA. All of them have retaliation bundled under them, or that couples them if an employee makes a complaint that falls in any one of these categories. What do you need to do to make sure that you can avoid retaliation complaints and prevent them from happening in your workplace? One of the things that you have to do is adopt, and distribute an anti-retaliation policy. And that policy should include some very clear statements around discrimination and harassment. Things like retaliation is prohibited by both law and our company policy, and that retaliatory acts that are against someone will lead to disciplinary action up to and including termination of employment. So it has to be really clear. It should also include an example of types of retaliatory conduct. What does that look like? You should also adopt and distribute anti-retaliation policy that includes how you're going to report retaliation. Who is that information reported to get that investigation started? How are complaints investigated, and ensuring they are investigated timely? And then also a statement that complaints will be maintained as confidential as long as reasonably possible. Because again, you may have to interview several people, and it's unreasonable to think that no one outside of that person will be interviewed related to that complaint, but certainly keeping information as confidential as possible. The other thing organizations must do is train their managers or anyone involved in employee relations on how to prevent retaliation complaints. They should receive a description of the company's anti-retaliation policy that we just talked about, and some of the critical information that should be there. Example of retaliatory acts, and even some role playing during that training session. And then information about the consequences if we retaliate against someone. So they should know clearly how retaliation will affect not only the company's bottom line from a financial standpoint, but also how it affects the brand of the organization. The company should also make sure that monitoring of employees who have complained about discrimination, that they are not being retaliated against. Again, if you have a case where the employees made a complaint against their manager, we want to make sure that the manager is not retaliating against that employee. And then we've got to investigate allegations of retaliation and take prompt action when we know that retaliation occurs. So in summary, a couple of things that you need to think about around retaliation. Retaliation occurs when an employer takes an adverse action against a covered employee. More employees are becoming aware of anti-retaliation protection. So we got to be on our P's and Q's when it comes to retaliation in the workplace and know exactly what it looks like. We've got to understand the difference between a whistleblower complaint and a retaliatory complaint, because they are different. And we also need to be aware of the laws that retaliation fall under, the Retaliation Protective protection falls under. Title VII, FMLA, FLSA, all of those laws, the age discrimination laws. Anytime an employee makes a complaint about any of these laws and their protection under them, and they're retaliated against, that becomes a protected action. If you don't already have one, you need to create an anti-retaliation policy. You've got to set up training so your managers and anyone who's dealing with employees, managers, supervisors, department heads, even your HR staff know what retaliation looks like and how it should be handled. You've got to make sure that you investigate any allegations around retaliation and take prompt action. And that is it. So I welcome any questions or concerns that you have. I'll share my contact information on the last slide of this presentation. This is a big issue. It's kind of hard to digest it all, and certainly trying to do it in 20 minutes is not enough time. But I just wanted to ensure that you had the basic understanding of what retaliation looked like and the risk that is involved if supervisors, managers, or even coworkers start retaliating against an employee for making a claim. I've got to give a big shout out to SHRM, which is the Society of Human Resource Management. They prepared this template slide deck, and I added a little bit more to it, but I want to give a shout out to them. They're a great resource for human resource management professionals to get the information that they need. So I definitely have to give credit to them. And last but not least, you've got my contact information. So I would love to hear from you with any questions, comments, or concerns that you have. Have a good one.